Real-world supervision and liability, where brokers get tested. As we continue building on the standard of care and legal exposure, this section focuses on real-world brokerage scenarios that test a broker's supervision, liability, and decision-making. These are not theoretical situations. These are the exact issues that lead to complaints, audits, and lawsuits. The key theme throughout this section is clear. Liability is determined not just by what you do, but by how you represent yourself and your brokerage. Agent selling their own property when the broker is not liable. When an agent sells property they personally own and properly discloses that they are acting as an owner-agent, the broker is generally not liable, provided the agent is not acting on behalf of the brokerage. However, this changes immediately if the agent creates apparent authority by using the brokerage office, branding, or resources. This reinforces a critical lesson. How the transaction is presented to the public determines liability, not just the intent of the agent. Definite place of business, ARS, paragraph 32-2126. Compliance Arizona law requires that a broker maintain a definite place of business. Leasing space in an executive suite is only compliant if the broker has a consistent, designated space, not just occasional access. This requirement ties directly into supervision. Without a defined place of business, it becomes difficult to maintain records, supervise agents, and ensure compliance with AAC R4-28-1103. Online activity, supervision, extends to digital platforms. If an agent operates a website designed to generate clients, even if it involves reviewing other licensees, that activity likely requires a real estate license. As a result, the broker has a duty to supervise that activity. This is especially relevant in today's market where social media, reviews, and online lead generation are common. The takeaway is simple. If it generates business, it requires supervision. Dual agency and confidentiality, protecting information. When a brokerage represents multiple parties in a transaction, confidentiality becomes critical. Even within the same brokerage, agents cannot share confidential terms such as price or closing details without written authorization. This reinforces fiduciary duties and highlights the importance of proper documentation and disclosure when operating under limited representation agreements. FSBO scenarios, when the brokerage is not involved. If an agent sells their own property as a FSBO without involving the brokerage, no office use, no branding, no representation, the brokerage is generally not liable. However, similar to earlier scenarios, the moment the agent uses brokerage resources or creates the appearance of representation, liability may attach. This again emphasizes apparent authority as a major risk factor. Listings and brokerage control. Who owns the client relationship listings belong to the brokerage, not the agent. However, a broker may cancel or assign listings if both the broker and the client agree. This is especially important during agent transitions. Brokers must balance contractual rights with client relationships and business strategy. A legal right does not always mean it is the best business decision. Unrepresented buyers, proceeding with caution. A buyer is not required to have representation in a transaction, even when dealing with a listing agent who is also the seller. However, this creates increased risk. The brokerage should clearly document that the buyer is unrepresented and understands the limitations of the relationship. This ties directly back to disclosure and risk management. Clarity prevents claims. Commission credits, flexibility within the law. A buyer's broker may credit a portion of their commission toward the buyer's closing costs. This is a powerful negotiation tool, but it must be properly disclosed and documented. This ties back to compensation rules under ARS, paragraph 32-2155. Flexibility is allowed, but structure and compliance are required. Real-world example, the risk of apparent authority. Consider an agent selling their own investment property but hosting open houses at the brokerage office and handing out business cards with the brokerage name. Even if they intend to act independently, they have now created apparent authority. If a dispute arises, the brokerage may be pulled into the claim. This reinforces a critical takeaway. Perception in real estate can create liability just as quickly as action. How this section connects forward. This section ties together supervision, agency, compensation, and standard of care into practical, real-world decisions. It highlights that most liability issues arise not from complex legal problems, but from everyday situations handled incorrectly. As we move forward, we will continue to focus on how brokers can create systems and policies that prevent these issues before they occur. The goal is simple: Control the risk before the risk controls you. Online discussion. Question 1. What is apparent authority and why is it important? Answer. Apparent authority occurs when an agent appears to represent the brokerage, creating potential liability even if the broker was not directly involved. Question 2. Why must brokers supervise online activity? Answer. Because online platforms used to generate business are considered licensed activity and fall under broker supervision requirements. Question 3. Why is documentation critical with unrepresented buyers? Answer. Because it clarifies the relationship and reduces the risk of misunderstandings or future claims.